Thank you, Mr. Chief Justice, and may it please the Court. The government's defense of the Names Clause, as the discussion so far this morning shows, begins and ends with its argument that the clause should be subjected only to rational basis review, not any form of First Amendment scrutiny. That is incorrect. For three reasons, the clause should be subjected to heightened scrutiny. First, the clause withholds valuable legal protections generally available to all trademark holders who pay the fee, including presumptive validity, protection against certain defenses, and incontestability, and it does so based solely on the applicant's speech. That selective, content-based withholding of generally available legal protections is a substantial burden on speech. Second, the Names Clause leverages the registration system and its attendant rights and benefits to achieve a purpose wholly unrelated to the purposes of trademark law, unlike the separate prohibitions on false association and marks likely to confuse or mislead, both of which are tightly connected to the purposes of trademark law and trademark registration. The government's interest in discouraging marks because they hurt the feelings of public figures has nothing to do with the purposes of trademark registration. Third, the Names Clause involves express speaker-based discrimination of the kind that lends itself to viewpoint discrimination. Under the clause, public figures may use their names on registered marks to express their own presumably positive views about themselves, but no one else can unless they get consent. And who is going to consent to a critical mark? These three reasons require rejection of the government's rational basis test, and once that test is rejected, the clause cannot survive. The sole interest that it sought to serve was protecting the feelings of famous people, but that is not a legitimate reason to burden protected speech, much less one that can satisfy scrutiny. I welcome the Court's questions.
Mr. Taylor, can your client make the shirts or mugs or whatever he wants to make now without registration?
He can, Justice Thomas.
So what speech precisely is being burdened?
The burden on speech is that my client is being denied important legal rights and benefits. What this Court has recognized 4 cases running now are important legal rights and benefits that are generally available to all trademark holders who pay the registration fee solely because his mark expresses a message about a public figure.
Is there a distinction between being able to speak and being able to register that speech in some form?
Well, Justice Thomas, I think there's no dispute, or at least I don't take my friend to argue otherwise, that the rights and benefits here are valuable. The entire registration system is predicated on the idea that they're valuable. It's why people go through the trouble of registering their marks. It's why they pay hundreds of dollars in registration fees, and often many times that to obtain legal counsel to help them through the process. It's because they matter.
Well, I understand that, but if your argument is that somehow your speech is being impeded, I think it would be good to know precisely how it's being impeded or burdened.
Yeah, so the way I would characterize it, our position is that when the government withholds important, generally available legal protections solely because of the content of the applicant's speech, that imposes a burden on speech because it effectively pushes them to use different words to receive equal status in the eyes of the law.